fantastic talk in the offing. Sophie is a doctoral candidate at the Open University, and she's been working on Victorian inquests for how long is it now, Sophie? So it must be about 3-4 years.
If you include my MA, I think it's 6 years now.
6 years. 6 years of sudden death from the Victorian period, and she comes already. She's a fantastic speaker, and this has been a talk that's been long in gestation and much looked forward to by, I'm sure, pretty much everybody in this room. So I will essentially just hand over to you, Sophie. You can do as you wish with what you've got. I don't know whether you want to share your screen or something.
I will.
Splendid. And there'll be lots of opportunities at the end for questions and so forth. And I'll just shut up now and let Sophie wow you with some pizzazz.
Some horror. Thanks very much, Stu. Before we begin, I would like to just give a brief content warning. This talk covers some sensitive topics, including suicide, murder, including the murder of young children, injury description and poison description, and obviously death. So, as Stu explained, my PhD project is about sudden death in Peterborough and how it was rationalised at inquest during the period 1856 to 1905. I've never really bought into the theory that people coped better with death and dying in the past, so I want to know how these sudden deaths were processed by family, by friends, by neighbours, and how and why certain decisions were made at the inquests. I am especially interested in how communities coped with homicide, whether it was intentional or otherwise. Come on, work. There we go. Inquests are a magnificently useful source for family historians. They're full of information about work, about family relationships, about housing and environment, and you sometimes get glimmers of personality shining through. But they're not a very popular source in academic history, and there's a really good reason for this. They don't very often survive. Unless the inquest concerned a prosecuted homicide, there was no obligation to keep or copy the statements of witnesses at inquest, also known as the depositions. In homicide cases, where someone was sent to trial, you may find the original inquest in the assize files at the National Archive, but not always. Inquest record preservation was in the hands of the individual coroner. In many, if not most areas, inquest records were burned or binned. As I recall, one lot of now archived inquest records in Lincolnshire were found in a skip. For some providential reason, this did not happen in Peterborough, where I live, and I have an almost complete run from 1844 until well into the 20th century, held by my local archive. They're not always very legible, but for my thesis period, I have access to the original records of 1,080 inquests, covering everything from heart attacks to brutal murder. Brighton's inquests survive from 1901 onwards, and they're stored at the Keep Archive if you would like to consult them. Original inquest records from the 19th century are handwritten. They're full of signed depositions with the verdicts written out formally on a separate paper. But there are also little treasures. Newspaper clippings, letters from interested parties, receipts for services rendered, and even suicide notes. This is the suicide note of Susanna Crampton, aged 20. It was addressed to her parents. She died of an overdose in 1855. This is only the last part, but she claims that people are telling lies about her, and she hopes that in heaven she will have no more to answer for. But movingly, you can see that the poison takes effect as she writes, and her writing becomes larger and more irregular. Her final words say, "So, goodbye." But a lack of original records doesn't mean we can't find out about inquests in other places. There is a stereotype that the Victorians were prudish. They were easily shocked, they were delicate. They weren't. The Victorians had an appetite for violence and pain that was fed by a newspaper diet of crime and inquests. Brighton had several newspapers in the 19th century. Indeed, my husband's family were the proprietors of the short-lived Brighton Patriot, until repeated libel cases bankrupted them. The Brighton Gazette reported inquests in detail throughout the 19th century, both ones from the town and further afield, and much of tonight's talk is derived from those reports, which could be reported rather briefly, like this one, or in extensive detail. The more dramatic the death, the more column inches in the local press. The role of coroner has existed since at least the 12th century, and my research actually suggests it's an office that predates Norman conquest and possibly dates to the reign of King Alfred the Great, citation needed. Originally, coroners were appointed to recoup valuables for the crown, and coroner comes from the word crowner. Treasure, shipwrecks, even washed up sturgeon, like this one, were all under the jurisdiction of the coroner. In fact, treasure still is. If you dig up a Roman hoard in your garden, the coroner decides who gets to keep it. The medieval coroner was also called upon to judge the cause of death. What has that got to do with valuables? Well, if someone committed suicide, their goods were forfeit to the crown, and so were the goods of those executed for murder. In determining the cause of death and whether anyone was directly responsible, the coroner was able to determine whose goods were forfeit. As the coroner's office was so old, the jurisdictions of coroners could be complicated. Brighton is an excellent example of this. Until 1855, Brighton's inquests were done by the coroner for East Sussex. Brighton became a borough in April 1854. In mid-December 1854, the Borough Council were awarded the right to hold their own quarter sessions, and this included the right to appoint a borough coroner. However, inquests in the surrounding towns and villages, including Hove, still came under the jurisdiction of East Sussex, a county coroner who was appointed by an election of the franchise men living within East Sussex. It was not unusual for areas to have multiple apparently overlapping coroners. For example, York had 3 coroners, one for the borough, one for the county, and one for the area directly around the cathedral. More locally, Winchelsea, Rye and Hastings also had their own coroners, a hangover from their medieval significance as port towns. In 1854, Brighton's new council had a choice to make. A coroner had to be either a lawyer or a doctor, although there were exceptions. A coroner in Durham was appointed on the basis of his service in the East India Company. A coroner was preferably versed in medical jurisprudence, but with a fair body of experience. In the medieval period, he had to be a knight, but the Victorians settled for men who had some estate. It was important that the coroner was financially stable, because he was expected to fund his own inquests and cross his fingers that the magistrates' bench would reimburse him at each quarter sessions. This man, John Croucher Penfold, a local solicitor, publicly asked to be appointed coroner, but he was ignored. He was in his mid-20s, but he was newly qualified, inexperienced, and still lived with his parents. Instead, David Black was appointed on New Year's Day 1855 and oversaw his first inquest 2 weeks later, before the magistrates had even had time to agree his fees. David Black was 37 when he was appointed. His father had been in service to Imperial Russia, and his wife's father was Prince Albert's personal portrait painter. David had come to Brighton in the 1840s and lived in various houses on Ship Street with his wife, children and staff. There's a blue plaque to mark one of them, and one of the other ones is now an Ask restaurant. He was a town solicitor, a partner in Black and Freeman, and later served on the Borough Council as clerk. However, he held the office until he died in 1893, but his wife died in 1875, and soon after, David suffered a stroke which paralysed him. All his subsequent inquests were delegated to his deputies. His deputies were Alfred Freeman Gell and Joseph Edward Bush. After Black died, Joseph Bush took over and held office until 1925. But we'll come back to the Black family and Joseph Bush later on. So by the 19th century, the coroner's main role, whether he worked in England or Wales, was to decide how someone died after a sudden or violent death, much the same as it is now. This included all deaths in criminal custody, deaths in asylums, the deaths of young children in the care of nurses, deaths where the deceased had not seen a doctor for more than a couple of days, and your expected murders, suicides and accidents. The coroner was not compelled to hold an inquest after a death in the workhouse unless there was some other suspicious circumstance. People went to the workhouse in extremis. If every death had warranted an inquest, the coroner would have been there every day. An inquest is an inquisitional hearing. It doesn't seek to attribute guilt for a death, only to find out the facts, although it can name suspects. However, the Victorian coroner had a power that modern coroners do not. He could indict people for murder or manslaughter. These indictments formed the basis of prosecution, although the coroner couldn't make the witnesses reappear for the trial, so they were usually reinforced with a second indictment raised after a hearing in the police or magistrates' court, because they did have the power to bind witnesses. Unlike today, the coroner did not act unilaterally. Instead, he had a jury of 12 or 13 men to come to a decision. Modern coroners may still call a jury, but it's usually only after deaths in prison or at work. In the 19th century, juror qualification was simple. They had to be male. They had to be able to write their own name, although some could not. They had to live in the parish or borough of the inquest, and they could not be convicted felons. There was no property qualification, although certain professions, including the clergy, practicing medical men and lawyers, were barred from acting as jurors. A typical jury in Peterborough comprised shopkeepers, artisans and publicans, and it seems that Brighton's jurymen were similar. Today, as some of you will know, although inquests are opened very soon after a death, they often drag on for months, even years. The Victorians had no way of preserving bodies. There was no refrigeration, so time was of the essence. Where possible, the inquest was held on the same day or the next day. Inquests could not be held on Sundays, Christmas Day or bank holidays, so sometimes a gap of 2 days was inevitable, but there was never any delay. In my Peterborough data, the fastest inquest was held 5 hours after the death. The first part of the inquest was the view, during which the inquest personnel went to look at the body, both to check the person was really dead and to detect any obvious causes, such as a knife sticking out of someone's back. I cannot tell you what a grim job this could be. A body that has been in water for more than a few days bloats, rots and stinks. A body that has been hit by a train may be in fragments rather than pieces. And remember that this jury was drawn from the men who lived nearby. They may well have known the deceased, even if they could barely recognise them. The jury could not opt out of this part of the inquest, even if they rushed through it, and it wasn't removed from standard practice until 1926. It was a deeply traumatic experience. The body was often viewed at the scene of death, but sometimes bodies were moved either to the site of inquest or to a larger space, particularly if the victim died in public. So where were inquests held? The idea of the coroner having his own courtroom did not really take hold until the latter part of the 19th century. The first purpose-built coroner's courts opened in London from 1878 onward, but didn't really take off outside the big cities. Brighton never got a coroner's court and today holds most of its inquests in a lodge at the entrance of Woodvale Crematorium. Inquests were, and still are, supposed to be open to the public, so the coroner needed a space where there was room to store and view the body, if necessary, and then retire to another room to hear witnesses and debate the cause of death. The inquest site also needed to be within the parish of the site of death as close as possible, particularly if the body needed to be moved. It also needed to be accessible at short notice because, as we've mentioned, inquests did not wait around. Therefore, a considerable number of inquests were held in public houses. There's no lack of pubs in Brighton, and many inquests were held in hotels, which had a bit more space. This is the Richmond Hotel, formerly of Richmond Place, site of the inquest of Joseph Pegler in 1874. Joseph lived on Richmond Place and cut his throat in a shed after getting into considerable debt. Joseph had been suicidal for a while, but perhaps against her better judgment, his sister-in-law sent him to clean their household knives anyway. She found him dead soon after. However, it appears that the Brighton coroners would hold inquests wherever was closest. In 1 week in 1872, David Black held inquests on babies at each of these pubs: the North Star Inn on Francis Street, the Spread Eagle on Albion Hill, and the Eagle on Gloucester Road. The process of inquest was reasonably simple. A death was reported to the coroner, by the police, by a doctor, by a registrar, or by a neighbour. There was no need for the informant to be anyone official. If someone was simply suspicious about a death in their locality, they could ask the coroner to investigate. The coroner did not have to hold an inquest into every death he was alerted to, but a good coroner would do a preliminary investigation regardless. Once the coroner was informed, he took legal possession of the body. It could not be buried without his permission. His officer, usually a police officer from the locality, summoned a jury and witnesses. The coroner then swore in the jury and took them to view the body. Following the view, the jury, the coroner, the coroner's officer and the witnesses moved to the venue, which may or may not have been in the same place as the body. Sometimes, not always, a clerk attended to write the depositions. The family were invited, representatives from the press and representatives of interested parties also attended. The coroner's court was really busy. There were a lot of people there. This is an engraving of a coroner's court in 1840, presided over by Thomas Whately, a very famous London coroner. This inquest was held in the pub, but not in the bar. You can see the clerk, you can also see the jurors, and this chap here is Charles Dickens in his role as court reporter. You can see that this is a room of mainly men. The witnesses gave their evidence. In this engraving, the witnesses are represented as a woman and a child. A child, as long as they could swear on oath to tell the truth, anyone could give evidence. Children as young as 6 gave evidence in some of the inquests in Peterborough. Today, medical evidence forms the foundation of the inquest, but it's not unknown for Victorian inquests to have no medical evidence given at all, or for the evidence to be very superficial. The coroner had the authority to order post-mortems, but they were not cheap. A medical witness cost £1 and 1 shilling, and a post-mortem cost £2 and 2 shillings. Although the coroner could get this money reimbursed, they initially had to pay it out themselves. And post-mortems were viewed with some dread by the Victorians. They were very closely associated with dissection and with punishment. So forensic medical evidence was sometimes avoided, out of considerations of cost and of decency. During the inquest, the coroner posed the majority of questions. However, the jury were allowed to question witnesses, as were parties with an interest in the case, including those suspected of murder. One of the exceptions to this was following a suspected infanticide. The mother of a dead newborn child, the person most likely to know exactly what happened, was very rarely present at inquest. This was because she'd just given birth and was considered unfit to attend, but it's an omission that really stands out in an otherwise open courtroom. After all the evidence had been heard, the coroner summed up the case and gave the jury a choice of verdicts. The jury then retired, usually quite briefly, and returned the verdict they felt was the best fit. The verdict was written up, signed and sealed. This is an example from my case files. Look at all the nice neat seals, they're all wax, they're lovely to touch. The jurors were also empowered to make comments on the circumstances of the case, suggesting safety improvements or admonishing lax parents. The jurors at inquest were paid, although it was a nominal fee, only 1 shilling each. They could donate their fees to the grieving family if they were moved to do so, and indeed there was often pressure for them to do so. At one inquest in Peterborough, a juror declined to donate his fee and was pilloried in the local press. So what verdicts were available? Natural causes. This covers everything, from seizures to childbirth to exposure to aneurysms. The inquest was usually called either because the death was very, very sudden or because it happened in public. From 1887, anyone who died who had not been recently attended by doctors required an inquest. You might expect natural causes deaths to be a bit boring, but they sometimes highlight abuses. For example, the man in Peterborough who died on arrival at the workhouse. The people who moved him to the workhouse were accused of being unduly rough and hastening his death, but the jury ultimately decided that his death was natural. There were also some really strange decisions within this verdict bracket. Until the very end of the 19th century, non-violent child neglect was not really prosecuted. 10 children starved to death in Peterborough during my thesis period. 5 of them were given natural causes verdicts. The next kind of verdict was accidental death. There was virtually no health and safety law in the 19th century outside the mining industry, and only then very lightly. There were some laws concerning factory work, but nothing around, for example, working at height, even when the height was a 300-foot tall mill chimney. In industrial cities and railway cities like Peterborough, there were dozens of work-related deaths. People trapped in machinery, people hit by trains and carts, people falling from great heights, like mill chimneys. One guy in Peterborough was killed when a steam crane fell off an embankment directly onto his head. This poor lad in Brighton, Henry Leggett, was only 16 when he hid in a cupboard in the newly converted Royal Concert Hall to scare his workmates, jumped out, and fell over a balustrade. As you might expect in a seaside resort with a fishing fleet, a fair proportion of accidental deaths in Brighton are drownings. Nationally, accidents accounted for around 40% of all inquests. In Peterborough, it was a bit higher at 50%, but Brighton is below average. It's about 1/3 of all inquests are accidental. Now to deaths that are intentional. First, suicide. Suicide was a crime until 1961, and its criminality was assessed in the coroner's court. Suicide verdicts could only be returned if the jury were absolutely sure that the death was intentional beyond reasonable doubt. There were 2 classifications of suicide under 19th century law, and they concerned the state of mind of the deceased. After a suicide, the coroner's jury decided whether or not the dead person was insane when they died, and the vast majority of suicides were deemed to have taken place while the deceased was either temporarily insane or in a state of mind unknown. Over time, suicide came to be considered an insane act in and of itself. Attempted suicide was regularly punished by imprisonment in the 19th century, and the legal penalty for suicide while sane, as I mentioned earlier, was a forfeiture of goods. Life insurance would not pay out, and for a substantial period of the 19th century, criminal suicides were denied Christian burial. Criminal suicide was known in the law as felo de se, to make a felon of oneself. The girl whose suicide note I showed you at the start? Felo de se. Why? Well, she planned it. And she did it while the rest of the household were in church. And she just lost her job because she was caught having sex with her co-worker in a barn. Felo de se was a moral verdict as well as a legal one, but it was vanishingly rare, virtually extinct by 1900. Next, homicide, my favourite, but also the rarest. Murder was rare, getting a coroner's jury to recognise it was even rarer. There were various kinds of homicide recognised at inquest: murder, manslaughter, justifiable homicide and execution. Justifiable homicide was really, really rare, and executions only happened in cities with the right to hang their criminals. So not Brighton. Sussex executions were carried out in Lewes. Everyone knows Brighton is murder central, but the statistics don't actually support this claim to fame. The national percentage of homicide identified at inquest, which is not the same as the amount of homicides that go to court, was just under 1.5%. In Brighton, it was slightly over 1%, except in a few extraordinary years, but murder is random and unpredictable. As I mentioned earlier, the Victorian coroner could name and indict suspects for homicide in their verdict. When this happens, the verdict itself is physically different. It's written on parchment instead of paper. Our last type of verdict is a narrative or open verdict. This is the verdict when nothing else fits, when a death went unwitnessed and might have been a suicide or an accident or even a murder. The jury could return a narrative verdict. Here's one from Peterborough in 1856 to show how the verdicts were written to exclude other interpretations of the event. John Tom Swales was born at Glinton aforesaid on Sunday the 20th day of April instant, and was at his birth a perfect formed infant, but directly after his birth, his grandmother Sarah, the wife of Thomas Baines of Glinton aforesaid, administered him a small quantity of a certain spirituous liquor called gin. And on Wednesday the 23rd day of April, the said John Tom Swales was seized with convulsive fits, from which he in some measure revived, but languished until Saturday last, the 26th day of April instant, when at the hour of 7 in the evening on the same day he died. And so the jurors find that the said John Tom Swales died of the said grievous disease, namely convulsive fits, produced and caused by the imprudent administering of gin, ignorantly by his grandmother, the said Sarah Baines, and not otherwise. I don't know how they could write it like that and not die. Baby John Swales' death was not an accident. His grandmother gave him the gin knowingly. Neither was his death a homicide. Alcohol was often given to babies. Medicine designed for the very young was full of booze, so Sarah wasn't doing anything odd or homicidal by giving the baby gin. His death could even have been natural. Seizures are usually seen in babies that have suffered birth trauma. The only reasonable verdict for the jury, however, was a narrative one, although it very firmly placed the blame on Sarah Baines. Narrative verdicts meant that the inquest could be reopened at a later date, if necessary. Some narrative verdicts are reasonable. Bodies are washed up and nobody sees the person go into the water. People fall down the stairs but nobody sees whether they slipped or jumped or fainted. Overdoses, especially for those with a history of abusing opiates, were also difficult to sort out into accident and suicide. Sometimes there's just not quite enough evidence to definitively give a verdict. To show you how these verdicts worked in practice, I'm going to talk about 3 homicides that shocked Brighton in the latter 19th century. Brighton was a leisure town with a large movable population, and there were loads of inquests. A brief analysis of inquests in census years suggests that there were around 80 a year, but with peaks of up to 150. Around 55 to 60% of inquest subjects were male. As you can see from this graph, there's a sizable chunk of natural death inquests, perhaps reflecting Brighton's convalescent population, and not many narrative verdicts at all. The Brighton coroners were very sure of themselves. But the number of homicides recorded in 1861 surprised me. 35% of all inquests in Brighton that year were given a homicide verdict. As I mentioned, murder is rare. 26 homicides in one area in 1 year is a massive anomaly. And it transpires that this was the result of Britain's first major rail disaster, the Clayton Tunnel disaster. Clayton Tunnel is just north of Pycombe and is 1.5 miles long. On Sunday, 25th of August 1861, 3 trains left Brighton station on the same line. They were supposed to leave across 45 minutes and were certainly not supposed to leave any closer than 5 minutes apart. But due to delays, they all departed within 7 minutes. The first left at 8:28 a.m, the second at 8:31 a.m, and the third left at 8:35 a.m. It being a Sunday in late summer, these were not commuters. These trains were packed with families on days out and people returning home to London and beyond after spending time in Brighton. The tunnel had an automatic signal, which was triggered by trains entering the tunnel's section of track, a brand new invention. Once triggered, it told the signalman at either end of the tunnel that a train was inside. However, for some reason, train 1 did not trigger this signal, and the first 2 trains entered the track section a few minutes apart. As you can see, the tunnel entrance sits in a deep cutting, and the signalman could just see the steam in the cutting. He couldn't see how many trains were generating that steam until it was too late. When he saw the second train barrelling towards him, he waved a red flag. The driver of train 2 did notice this flag, and he cut off his steam and slowed down. But a fully laden steam train is a difficult thing to stop, and he was most of the way through the tunnel before he got the train into reverse. His plan was to move the train back to the beginning of the tunnel and go through once it was clear. But when the first train safely left the tunnel and carried on to its destination, it flicked the automatic signal to all clear. The signalman at the Brighton end saw this and assumed both trains had left the tunnel, and signalled with a white flag to train 3 that the tunnel was all clear. Train 3 entered the tunnel, and despite trying very hard to reverse when he saw the lights of the reversing second train, ran straight into the back of it. The collision took place shortly before 9 a.m, but it took place in pitch darkness. There were no lights in the tunnel at that time. 2 carriages were entirely destroyed by the impact, and the debris blocked the tunnel on the Brighton side, but it was actually impossible to see what had happened or what was happening. Those who could got out and fled to the London end of the tunnel, and word quickly got back to Brighton, who sent down a special train of doctors, surgeons and railway staff to assist. By luck, the final carriage of the second train was empty. It was entirely destroyed, reduced to dust, but the next 2 carriages were horrifically mangled and entangled in the engine of train 3. It took 2 hours to get the tunnel properly lit and retrieve the engine of train 3. 23 people were killed, with 22 dying at the scene, including women and children. The final victim died a few days later. Another 176 people were injured, and their injuries were horrific. Elizabeth Edwing was a toddler, and she survived the crash, but she was scalded from head to toe by water from the third engine's boiler and broke both her legs. Brighton Infirmary was full of victims for many weeks afterwards. The bodies were laid out in the Literary and Scientific Institute within the Royal Albion Hotel for identification. The inquest was complex. It opened at the North Star Inn, but later all hearings took place at the Town Hall. The inquest sat in 9 long sessions and didn't conclude until the 10th of September. It included a visit to the tunnel by the jurymen. Ordinarily, railway deaths were declared to be accidental, either because the person or people who had died were to blame or because it was just a freak event. But Clayton was different. No railway workers died. All the victims were passengers who could not possibly be blamed for this collision. The railway company, the London, Brighton and South Coast Railway, were cagey and difficult, refusing to produce documentary evidence concerning how the accident happened. And the coroner, David Black, threatened to lock the company's secretary up for being obstructive on the penultimate day of the inquest. Finally, the jury deliberated about the mountain of evidence they'd heard. It took them 4 hours and 5 minutes to return a verdict of manslaughter against Charles Legg, the assistant station master at Brighton, who had allowed 3 trains to leave the station in just 7 minutes. Charles Legg stood trial in March 1862, more than 6 months after the accident. And perhaps the horror had faded from people's minds by then, because the grand jury, a group of men chosen from the highest echelons of Sussex society, ignored the prosecution. Railway companies were powerful, and most men of means held railway shares, including the judiciary and other elites. It was not in their interest to give the public reason to fear or doubt the safety of the railway. Not one shred of evidence was given in court, and Charles walked free. He appears to have later been pensioned off by the railway company. Another horror was inflicted on Brighton less than a decade later, with the infamous chocolate cream poisoner. Christiana Edmonds was a wealthy young woman who had become obsessed with Dr. Beard, a local doctor. She was determined to win him away from his wife Emily, despite Dr. Beard's apparent lack of romantic interest. Christiana became convinced that she would have to kill Emily Beard and decided that the best way to do this was to poison her. In September 1870, Emily Beard became very ill after eating some sweets from Christiana, and the Beards believed Christiana had attempted murder. They didn't report this to the police, but they stopped seeing her socially, and in many ways this was a more drastic punishment for Christiana. Christiana began to experiment with poisoning doses, purchasing strychnine and putting it into chocolates before leaving them on chocolate shop counters for unsuspecting people to eat. Strychnine was widely available, usually sold as vermin killer. However, Battle's vermin powder was a readily identifiable shade of blue. So Christiana bought pure strychnine, direct from the chemist, signing false names every time. She bought around 50 grains between March and June 1871, enough to kill a minimum of 50 adults. At least 3 people later reported vomiting and suffering stiffness after eating chocolates supplied by Christiana in this period. So far, so non-fatal, until the morning of the 12th of June 1871. Charles Miller, aged 18, bought some chocolates from Maynard's chocolate shop on West Street. He ate some and felt so ill that he called a doctor. His breath was short, his limbs were stiff. But the doctor diagnosed him with hysteria, partly because Charles recovered so quickly. Charles continued to feel strange for the rest of the day, but the doctor assured him that the chocolates were not the cause of his symptoms. Charles was on holiday with his siblings and their children, including his nephew, Sidney Albert Barker. Sidney was 4 years and 2 months old. A few hours after the doctor had reassured Charles that he was merely hysterical, Charles offered his brother Ernest, then aged 15, and little Sidney some of the chocolates. They tasted wrong, bitter and disgusting, and Ernest spat his out, but Sidney was not usually allowed sweets, so he swallowed this unexpected treat. 10 minutes later, he began to convulse and go into spasms. A different doctor came to the house and sent for an emetic, a medicine to make Sidney vomit up the poison, but Sidney was dead before it arrived. The inquest was held at the Carpenter's Arms, later known as the Nellie Peck, on West Street the following day. David Black presided, and the jury were unconvinced by this tale of poisoning. And this is the part of the story you may never have heard before, because Christiana Edmonds almost got away with it. Strychnine is a dramatic poison. People poisoned by it die badly. It begins with a metallic taste in the mouth and small cramps in the face, hands and feet. Then the spasms rapidly intensify, contorting the body as the limbs become rigid, exhausting the patient. Seizures set in, which worsen with any external stimulus. When Sidney's mother tried to save him by washing his feet in mustard water, she simply intensified his pain. Eventually, either the respiratory system shuts down or the patient dies of exhaustion, and this can take some time. The larger the dose, the faster the death. Sidney died within an hour of eating a chocolate. The jury in Sidney's case did not witness his agony, his rigidity or his spasms. All they saw was a little dead child with his limbs relaxed but black in the face. And if they'd been jurors on other inquests, they may have seen this kind of death before, in cases of suffocation and seizures. They were immediately sceptical as to whether he had been poisoned. They wondered whether he'd suffered teething or whether he'd banged his head while playing. It was far easier for the jury to imagine that Sidney's awful death was natural or accidental than that it was caused by a random poisoning. Nobody wanted Sidney dead. He didn't know anyone in Brighton. He was on holiday. His whole family was shell-shocked. If this was a murder, it was a very odd one. But the doctor who attended Sidney recognised the description of symptoms and convinced the coroner, David Black again, of the necessity of a post-mortem. The post-mortem showed nothing untoward. The brain was normal, the stomach was normal. The stomach contents also seemed normal. No odd smell, no strange colour. The telltale blue of Battle's vermin powder was absent. The doctor told the court that if he hadn't seen the child and heard the history, he would have been happy to ascribe the death to natural causes. The jury continued to ask if the doctor was absolutely sure it wasn't teething convulsions, and the coroner adjourned proceedings so that Sidney's stomach contents could be analysed. And when the inquest reconvened, the analysis confirmed the worst. There was 1/4 grain of strychnine in Sidney's stomach. The inquest jury actually came to the conclusion that Sidney died because of contaminated chocolate, and that the chocolate had been contaminated by the use of rat poison at Maynard's factory. Sidney's death entered the records as one of 2 narrative verdicts in Brighton that year, and Maynard's factory was publicly embarrassed and promised to clean up their factory. It took another 2 months for the law to catch up with Christiana, who audaciously attempted to poison Mrs. Beard again by sending her a cake with 8 grains of arsenic, among other poisoned items, enough to kill the whole family twice over. Sidney's murder was not immediately connected to Christiana's case, but she was tried for it in January 1872, found guilty and sentenced to death. Her death sentence was commuted because she was insane, and she spent the rest of her life in Broadmoor Psychiatric Hospital. I don't think Sidney was Christiana's only victim. Sidney's inquest shows how unwilling a jury was to believe that someone had been poisoned, even when witnessed. There were 40 natural death inquests in Brighton in 1871, and it's possible that Christiana's chocolates were responsible for at least one of them, but it's impossible to know for sure. And so to our last and most distressing case. David Black, the coroner, had been ailing for close on 20 years in 1893. After his wife's death, he was supported by his many talented children. The eldest was Arthur, born in late 1851. He had a weakness in his right arm, most likely from a birth injury, but he was not disabled by it. Arthur was educated at Brighton College and then University College London. He qualified as a solicitor, but he worked as a mathematician and sometimes as a teacher and tutor. In 1886, he married Jessie Kelly, a woman half his age. They moved to Hove and lived at 77 Goldston Villas, a fine house. This is not his house, but it's one very similar. They had a daughter in October 1887 and a little boy in December 1891. And on the 17th of January 1893, Arthur Black murdered his wife and baby son and killed himself. The Black murders took place in Hove, so the borough coroner was not obliged to oversee this inquest. But it was still quite a complicated inquest to organise because the East Sussex coroner was a friend of the Blacks, so he sent his deputy, and the deputy coroner for Brighton, Joseph Bush, represented the Black family. The bodies were discovered on the 19th of January, and the inquest convened the following day at Hove Town Hall. The main witness was Ernest Black, Arthur's brother. He was 5 years younger than Arthur, equally respectable, and had seen his brother relatively recently. He said that Arthur was a temperate and sober man, although he was a touch depressed, and had been struggling lately for work, although not for money. Ernest had no kind words for Jessie Black. He said she was intemperate, meaning she drank, and that she was eccentric and trying in her habits. She was jealous, mercurial, and indecisive. She didn't clean the house, and she didn't take care of her children. But there were undertones of misery and abuse, even in this one-sided picture given by Ernest. The Blacks had sent their daughter, who had just turned 5, to live with Arthur's sister because she was being so neglected. Nobody asked Arthur's sister to speak at the inquest, so the true conditions of the girl's adoption remained mysterious. Their baby boy had been made to sleep in the basement at Arthur's instruction because he didn't want the baby in his bedroom. They had no servants, allegedly because Jessie was too unstable. Jessie claimed that she often felt she was being strangled, which was taken as a sign of her instability. But a petticoat was tied around her throat when she died, and she was shot in the throat. Maybe David enjoyed strangling her, something commonly seen in spells of violence. A servant named Elizabeth Eastwood, who occasionally went in to clean, said she had nursed Jessie through a period of postnatal depression the previous year, but no doctor had attended or been called. This servant said that Jessie was not a big drinker, but she did occasionally scream a lot for no reason. The same servant had seen Arthur a few days before the murder and said he had a wild and changed look about him. On Tuesday morning, a neighbour heard 2 shots fired, but thought nothing of it. Now, if I heard 2 shots fired at 7 o'clock in the morning, I would think something of it, but on Wednesday evening, a different neighbour saw Arthur looking very ill in the street. On Thursday morning, someone informed the police that Arthur had failed to attend a speaking engagement. The police broke into the house and the horror was unveiled. It seems that Arthur shot Jessie in the throat while she was in bed. The pillowcase was scorched and blooded. But Jessie didn't die. She pushed the gun away from him when he went to shoot her again, and the bullet went through his thigh. She appears to have ran downstairs, and when he caught up to her, he knocked her down with the pistol and then smashed the back of her head in with a hammer. Then he went to where little Walter, aged 13 months, was lying, and killed him with a hammer blow to the back of the head. And then he waited. He waited for more than 36 hours, perhaps wondering what on earth he should do. Nobody was likely to call on him, there were no servants. But there's no evidence that he tried to move or conceal the 2 bodies. Eventually, at some point between Wednesday evening and the early hours of Thursday morning, he went back to his bedroom and overdosed on chloroform. 2 doctors gave evidence. The second doctor gave evidence about Arthur. He'd known him well, he'd known him for years, and he really admired his academic work. He claimed that Arthur had been acting in self-defence, and that Jessie had shot him in the leg. But nobody spoke for Jessie. She seems to have had humble origins in London, and nobody was asked to testify about her experience of marriage. Indeed, the coroner curtailed the evidence after just 4 people had spoken, saying the jury had no appetite to hear more. Mr. Bush, representing Arthur, a man he had known very well for perhaps his whole life, suggested that Jessie was responsible for the whole thing. Then he suggested that Arthur and Jessie had fought and that baby had been killed in the struggle. He said, if Mr. Black had killed either of them, meaning Jessie or Walter, it would only have amounted to manslaughter. Only. Murder-suicide is a strange legal anomaly, a hideous crime that's tried only in the coroner's court. In the 19th century, the coroner's jury had to evaluate the facts of the crime as well as the more slippery aspects of motive, sanity and culpability. Whatever the coroner's jury decided, that's how the death went down in the record. There was no further trial, no opportunity to prove guilt or sanity. It was all on the inquest. And at the Black inquest, the jury decided that Arthur was responsible for the murders, but he was insane when he committed them. He had killed himself, but he was insane at the time. He bore no legal culpability for the deaths, although he was responsible. The 2 homicides were recorded in the national statistics as manslaughter. Would the jury have returned that verdict had this tragedy happened within a less well-connected family? I doubt it. All 3 were buried together, with the funeral held early in the morning to avoid any civil disturbance. And when David Black, the respected and long-standing coroner for Brighton, died just 4 months later, none of his obituaries mentioned the family annihilation. Arthur's sister, the social commentator and trade unionist Clementina Black, continued to raise his daughter. As Gertrude Speedwell Massingham, Arthur and Jessie's daughter stood for election twice in Petersfield and Maidstone. She was not successful, but she became a leading figure in the RSPCA. And these 3 cases demonstrate some of the oddities in evaluating homicide in the 19th century at inquest. A person could be found responsible for a death at inquest, indicted for that death, yet never stand trial. A person could avoid detection if the coroner's jury didn't think a murder had actually happened, and even the most brutal domestic murders could be gently swept away if it suited the jury. With that, my talk is done. Thank you so much for listening to this very cheery topic. Does anyone have any questions?